Hello, and welcome to the latest edition of the Sinclair's Law Education magazine. My name is Christopher McFarland, and I'll be your host for this session. Now, you may notice, if you're a regular viewer, that there's been a change to the current format, most notably that I've replaced our CEO and usual host, Mr. Michael Charles. For those of you who are regular viewers, please rest assured Mike will be back for the next edition, but for today he's asked me to step into his shoes. Now, the more things change, the more we stay the same, and today we'll be dealing with some topical topics for you in the field of education and law. The topics for today will be, firstly, back to school for pupils in England and Wales. When will pupils be returning and what arrangements can they expect when they get there? Secondly, we'll be talking about summer assessments in the summer of 2021, particularly for those who are going to be sitting their GCSEs and A-levels. Finally, we'll return to our case comment section. We'll be talking about the case of AB and the University XYZ, which talks about legal representation in university disciplinary proceedings. As ever, I am joined by two wonderful panellists who will help me discuss today's topics. And in keeping with Mike's tradition of enthusiastic introductions, may I introduce the talented and tenacious Charlotte Hadfield. Charlotte, welcome back to the show.
Hi, Chris.
Thank you very much. And of course, joining us, and this time for the first time, we have the clever and charismatic Lachlan Wilson. Lachlan, welcome to the programme.
Hello, Chris. It's a pleasure to be here.
Excellent. Well, without further ado, let's jump into our first topic, which is returning to school for pupils in England and Wales. So it's been no secret over the past year that the coronavirus has had a significant impact on the education of children, young people and their families. And today we're going to talk about the government's plans in England and in Wales for the return of students to school environments. Now, Charlotte, you and I are both parents, so we have firsthand, I think, had experience of what it's like to be both a full-time home worker and a part-time home educator. So can you tell us a bit about your experiences during this pandemic?
So it's been an interesting experience, and it's been quite different between lockdown 1 and lockdown 2, because I have, as you know, Chris, I have a preschooler who was 2 when the first lockdown happened, and during that time we swapped her between ourselves, and we both worked. Well, I work full-time, my husband works part-time, but we swapped her between us, and that was just about manageable. Lockdown 2, when she just turned 3, was more complicated, I think. I mean, I still wouldn't say that I was homeschooling in the way that I think you've been because of where she is in her education, but certainly it was that little bit harder, I think, to really kind of do both things, to be a working parent and to be a sort of full-time parent, which is obviously what a 3-year-old needs if they're not at preschool. So she has been going to preschool, and that, I think, has been more fun for her and easier for us. But obviously we're lucky because preschools have been open all the way through lockdown too. But yeah, no, I can imagine it's been a bit of a challenge. How's it been for you, Chris?
Well, I have to say, full disclosure, I have done some of the education, but my lovely fiancée has done the bulk of it. So she is really the home tutor. But it has been tough. I have 2 boys, so one 5 and one 11. So as we're coming on to discuss in a minute, we have this weird divide between, my youngest has now gone to school here in Wales and my eldest is still at home learning. I think, much like you said, Charlotte, it's really tough for the younger pupils, I think, to miss their friends. Obviously, for my eldest, he's able to speak to his friends online. He's got great IT skills, even at just 11 years old. So, he can deal with Teams meetings, deal with Teams projects online, and, he'll speak with his friends over the PlayStation, or they'll be able to have some fun together through that, or safely, of course. And for our youngest, however, that's not possible. 4 years old when lockdown first began, coming up to 6 this April, it's been really tough. Schools have been great and they've done the best they can, sending materials home and doing Teams meetings, but I have to say I'm really glad that today was his first day back and he was quite eager to return. So of course, with that in mind, Lachlan, so you've been looking at the latest guidance for us. So before we start on that, can you tell us what has been the practice so far during the lockdown for pupils in England and Wales?
I certainly can, Chris. And being childless in Dorset, I can tell you that even the Bournemouth beaches are aware that, from my dog walks at any rate, that we are in a period of national lockdown. And what, of course, that means, even though the government was particularly late to come to it, is that schools are closed to everybody, apart from critical workers, children, and vulnerable children. So unless you belong to that category, you should be, your children should be receiving remote education. We could talk about the differences up and down the land that remote education amounts to, but that might be a topic for a whole webinar on another day. But there we are. So children, only children of critical workers or vulnerable children should be receiving their education face-to-face at school. Otherwise, all other pupils, remote education. Pupils who are self-isolating are expected not to attend school, and clinically extremely vulnerable pupils are advised not to attend school, but it should not be a reason to exclude them if actually they wish to attend school. And schools are asked to continue to record absence in the register, but in these cases, there will not be any penalties for non-absence, whether that's absence in the face-to-face setting where they are expected to be, or whether indeed that's absence in the remote setting, not attending the Zoom or other remote platform that has been provided from. So there won't be any penalties for absence, and in fact the absence for those pupils who are expected to attend school will be recorded as with an X as an authorised absence as a result of the pandemic. I can go on with a definition of critical workers and vulnerable people if you would like me to, Chris.
Always, Lachlan. I'm always interested to hear you give us definitions for critical workers and vulnerable pupils. Please carry on.
Well, it won't surprise you to know that the government has issued guidance and the definition of what is a critical worker. And that comes in guidance. Work is critical to the coronavirus and EU transition response. So parents who are responsible for responding to both to pandemic and the EU transition are interestingly identified as critical workers. And that includes people in health and social care and other key sectors, as you can imagine, to keep the country going. Interestingly, children with at least one parent or carer who's a critical worker can go to school if required. It doesn't require both parents. That's even if the other parent, for example, may be working from home in a non-critical capacity, but they are still entitled to go to school. Schools can ask for simple evidence that the parent in question is a critical worker. The prospect of schools asking for pay slips or even work ID badges seems a little draconian, but they are entitled to, if they wish to, if there is any dispute as to whether or not the parent is a critical worker. And parents and carers who are critical workers are enjoined in the government guidance to keep their children at home if they can. So it's not a prerequisite that parents of critical work, that children of critical worker parents should go to school. It's not a requirement that they do go to school. It is an entitlement. Quite different in terms of vulnerable people. Definition of vulnerable people includes children who either are assigned a social worker or have an education, health and care plan, or who may be vulnerable for another reason at local discretion, otherwise vulnerable. With those children, schools are expected to allow and strongly encourage their attendance. And obviously that's from a safeguarding perspective, that is put in place. So children of critical workers have the entitlement to attend school. Vulnerable children should attend school, and the guidance is strongly to encourage them to attend school and for schools to remain open for them.
Excellent. Thank you for that wonderful summary. Now, of course, we are well into lockdown 3 at the moment, so I'm sure those of you who have vulnerable children or are key workers have already had this experience in practice about your children attending school, or at least having the option to attend school. But change is on the horizon. So Charlotte, can you tell us a bit more about what the expectations are moving forward for the return of pupils to school?
Yes, so it is expected that children in England will go back to school from the 8th of March 2021. And so far as Wales is concerned, it is expected that foundation stage children, foundation stage children, I think are back, aren't they, Chris? They went back on the 22nd.
That is right.
The children still consulting, but it's looking like it's going to be the 15th of March. In terms of what in terms of what the regime is going to be, attendance is going to be mandatory. So that's a bit of a change in culture from where we've been over the last year. So in other words, parents will have a legal duty, as they did prior to the pandemic, to ensure that their children attend school, and the local authorities will be able to issue school attendance orders and enforce prosecutions and apply sanctions where parents fail to send their children to school without a reasonable excuse. Now, what's interesting, I think, and probably a point of considerable anxiety for some parents and families who are particularly anxious about COVID, is what a reasonable excuse is going to look like. And it's probably too early to say, but what we can say is that obviously some children will be shielding because they are clinically extremely vulnerable or because they're high risk. Those children will or should know who they are because the NHS should have proactively contacted them to make sure that they understood that they had that status. If parents have a child who they think may be clinically extremely vulnerable or high risk and they have not had contact from the NHS and they are concerned about their child returning to school because of that, those parents should be getting in touch with their GPs, or if their child is under the care of a consultant, the consultant right now, to get evidence about that child's status, because it is looking, Chris, as though if your child is not clinically extremely vulnerable or high risk, you may struggle to prove or you may struggle to defend action taken against you for not sending them to school. Now, this is going to be of a lot of concern to some families because we know that there are some children who are not themselves in either of those categories, but who are living with parents or other adults, relatives, caregivers who are. Obviously, those families are going to be very anxious about the impact of their children going back to school. And we also know that what schools are being told by the government is that where families have concerns like that, schools should discuss those concerns with parents, absolutely. The guidance is that schools should reassure parents and families and children about the measures that they are taking in relation to COVID, because schools will continue to need to take certain measures in order to minimise the risk of transmission from COVID once schools open. But schools are also being told that they must advise parents, families and children that school attendance will be compulsory. And so the general drift of the guidance, I would say, is if you're not clinically extremely vulnerable or high risk, but you don't want your child to go to school, if your child is not in those categories, but you don't want your child to go to school, you may have a bit of a fight on your hands, and you would probably want to get some legal advice about how best to approach it. Now, the thing to remember is that you always have the right to home educate electively. So if you are extremely concerned about a child going back to school, that is always something that you have the option of if you have parental responsibility for that child. And the only thing I think we'd say about that, Chris, is that home education is quite a big responsibility. It's a big commitment for caregivers. It's a very different experience for a child, and local authorities do police it quite rigorously to make sure that the child is being home educated and is accessing the curriculum appropriately. And so again, that is open to parents and caregivers. Parents and caregivers should obviously just be confident in themselves that they are capable of arranging an adequate home education if that's the road they decide to go down. But yes, it's looking, Chris, like business as usual from the 8th of March or the 15th of March, depending on where you are.
Absolutely. And as As our youngest went into school today, I have to say there was a mini celebration in our household. But of course, as you say, Charlotte, for those of us who have seen that the risk assessments are in our favour and have confidence in the measures put in place by schools, perhaps we can look forward to this return. But as you say, there will be those who, either through the vulnerability of their children, for their household, or a generalised concern, may have some anxieties about the return. And you've talked very pragmatically there about the steps to take. So I think in summary, you want to speak to the school, raise your concerns. It's understandable to have worries given the year that we've all had, and talk to the school pragmatically about the concerns and see what can be done to either put in place extra measures or further reassurance, or alternatively, maybe there should be a period of remote education for your child or young person, depending on their particular circumstances. It is, however, important to recognise that certainly within the English guidance, there is a strong emphasis on mandatory attendance. So that discussion does need to happen at the earliest opportunity. And as Charlotte neatly summarised, you do retain your rights to electively home educate. That means you choose to home educate and in so doing take upon yourself the responsibility to educate your child at home. Some people do this anyway, and many of them find that it provides their children with a wonderful education that they can differentiate themselves while still teaching the core curriculum. But of course, as Charlotte said, and I think as many of us have found over this last year, it is a challenge, particularly if you yourself are working from home at the same time. And there will be a requirement that you show that you're providing your children with education at home if you choose electively to do so. And if those children have additional learning needs or special educational needs, there will be an obligation on you as well to meet those needs in the home, and that can be a daunting prospect. So do make sure you have covered your bases and taken advice from institutions and even your local government that may have some advice on home learning resources that you can use at this time. Now, Lachlan, there's another point that we've been talking about returning to school, which is the use of masks in particularly secondary school environments. Now, it's quite normal for us all to wear masks these days out and about in the community, but of course for some of us that may not be possible. So, Lachlan, for those young people or parents with young people who may, for reason of disability, ill health or otherwise, be unable to wear a mask, what is your advice to them about how to approach the schools, and are they entitled to not wear a mask or maybe wear a different form of facial covering if required?
Certainly, Chris. And in fact, you've actually touched on the advice, and the advice is dialogue, dialogue, dialogue. Without a dialogue between parent and school, what would our education system be? If for any reason you're concerned because perhaps your child has sensory issues or perhaps they just have general anxiety created from the whole COVID pandemic, that wearing a mask at school is something they simply cannot cope with, then speak first of all with the school. Get a discussion going, find out how the school would react to it, and if you can, back your feelings up with evidence, if necessary, medical evidence, a medical note, especially if a child does suffer from sensory issues. You may already have that evidence available if your child has an education healthcare plan. The issues may be there, set out in the plan. And of course, if they are set out there in a plan, chances are your child is likely to be a disabled person within the meaning of the Equality Act, and you could remind the school of their duty to make reasonable adjustments even to their mask wearing policy that they're operating in those circumstances. But principally, Chris, the advice is discuss it first of all with the school. It would not be right, and I think, Chris, you can speak from personal professional experience on this. It would not be right to exclude a child because of a refusal to wear a mask. So that discussion has to be had with the school, but the school should be aware by now that going to the extreme of excluding because of failure to wear a mask is something the school should not be contemplating. But you as a parent must consider and understand why schools might find themselves torn, because there may be parents of other children at the school who are concerned about children entering the school who are not wearing masks. It's a difficult issue. It is one that needs to be discussed, and it's one that needs, ideally, to be agreed as between you and your child's school.
Absolutely. Thank you, Lachlan. So again, the rule is dialogue, dialogue, dialogue. The more discussion you can have with the school about your concerns or about the reasons why your child can't wear a mask, the more the school can understand and the more they should be doing to help your child attend school in a suitably adjusted way. And of course, as Lachlan said, if you do run into some difficulties, you can, of course, take advice from solicitors working in this area who will be able to assist and advise you. Hopefully that will not be required. And for any teachers or head teachers watching today, the rule is, remember there is that duty to make reasonable adjustments. Be flexible. Understand that there are general rules and there are always going to be exceptions to those general rules. The most important thing for any school is not to be rigid. Don't feel that these are set in stone. Listen to parents, try to understand their situation and try to talk to them about a suitable compromise. Whatever that is and whatever is suitable in those individual circumstances, the most important thing is to enter that discussion. Now, that leads us neatly, I think, onto our second topic, which of course deals with those pupils of an older age who are looking forward to their summer assessments. Now, looking forward may be a slight exaggeration on my part. I have to say I didn't look forward to GCSEs or A-levels when I had to sit them. But of course, for those sitting them this year, much like last year, the arrangement is going to be very different from those that we sat in years past. So we will now move on to discuss the arrangements for the summer 2021 examinations and what that means to children and young people in England and Wales. So it was headline news in the summer of 2020 that there was, shall we say, somewhat of a fiasco around the arrangements for A-level and GCSE exams, and in particular, the use of standardisation software. Now, thankfully, for the vast majority of pupils, they were able to overcome that issue once the guidance was changed by the government, and luckily, many of those have now gone on to pursue their A-level topics or university courses of choice. However, that sadly has not been the case for all students, and some students are still trying to fight for the grades they felt that they deserved following their hard work during an unprecedented year. Now, in 2021, we have learned that both governments in England and Wales are proposing that teacher-based assessments return. So what does that mean for the children and young people who are heading towards their GCSE and A-level exams? And what should parents and young people know about their rights and the expectations they should have for the summer examination period? So Charlotte, I think it bears repeating what happened a bit last year and what went right and what maybe didn't go so right, shall we say. So can you give us a brief summary about our experience in 2020?
Yeah, I can. So I think the headline is that it was an incredibly difficult, distressing and frustrating year for both GCSE candidates, A-level candidates, and of course, the often forgotten BTEC candidates, who so often emerged as a kind of afterthought in the examination preparations, despite BTEC being an incredibly important and significant qualification for an awful lot of people who keep our economy and our society running. Bit of a bugbear for me that the way the BTEC results were all, the BTEC arrangements were always a kind of poor relation to everything else. So what happened in the summer of 2020? Well, when we went into the first lockdown back in March of last year, the government was perhaps understandably very resistant to the idea that examinations would be cancelled. And as I say, that was understandable because it's really important to remember that we do have a school system that is largely set up to prepare children for examinations. And that is very different from a system that's set up to prepare children to be assessed continuously all the way through their school year. And the reason I say that is some kids love exams. I always responded best to exams. I think probably, barristers being who they are and very susceptible to time pressure and so on, probably most barristers would say that they were more likely to perform at their best in an exam. But an awful lot of children in the country respond better to coursework, and there's a lot of research about that. But the difficulty with the situation that we had was we ended up in a situation where the government had to accept that examinations couldn't take place because of where we were in terms of managing the pandemic, and because of the disruption to schooling that had been caused by everybody going into lockdown and some students being educated at home and a minority of students going into school. So what the government had to do was come up with a system whereby children who have been preparing for an examination and young people who've been preparing for an examination suddenly had to be assessed as if they were being continuously assessed all the way through their year. And there were always going to be some kids who came off worse in this, unfortunately, because, and again, I speak as a lifelong crammer for exams, the sad fact is that if you're somebody who likes exams and responds well to exams, you may not necessarily have the pedal to the metal all the way through the 2 years leading up to the exam, because you're assuming that you'll be judged on the basis of that final critical period in the summer. So the regime that was adopted was that teachers were to submit something called a centre assessed grade, which they arrived at based on a combination of different factors, including various internal assessments, the students' performance all the way through the exams, taking into account any issues that students had, such as a need for reasonable adjustments, or other mitigating factors such as bereavements and so on. All of those things had to be considered and adjusted and weighed in the balance in arriving at this thing called a centre assessed grade. And I think one of the difficulties is that students who were preparing to take A-levels had already had their A-level predictions considerably earlier, before lockdown, at a point where we were not preparing for this system. And I think that a lot of parents and children assumed, not entirely unreasonably, that if they had got a prediction of, say, 3 A's or 3 A stars, that their centre assessed grades would also be 3 A's or 3 A stars. And I think that this is where the system came unstuck. Schools knew that Ofqual would be developing an algorithm which was designed to moderate the centre assessed grades, because Ofqual had a concern, and we'll see in a minute that that wasn't entirely unjustified, that grades might be inflated by teachers who were carrying out predictions. And it is fair to say, I think, that the way that predictions have historically been arrived at for A-levels, it's not really a very standardised process. It varies massively both from school to school and from teacher to teacher. So it's always been a tricky situation. Some schools might predict grades aspirationally. Some schools might predict grades very much on the basis of what are you actually going to get? And that's a whole different conversation. So what happened with centre assessed grades were that some schools, this is kind of anecdotal, but my understanding is that some schools were concerned about their grades being moderated down. Well, all schools were concerned about their grades being moderated down. Some schools responded to that by being very cautious, because they wanted to submit a pattern of grades that would demonstrate to the exam boards and the regulator that they had been sensible and thoughtful about how they came to the grades that they had, and that they were predicting what children would actually get. Other schools perhaps approached it a little more bullishly and operated on the basis of, maybe, again, this is anecdotal and I can't name any specific schools that did this, but the word on the street, if you like, is that some schools may have approached it more from the basis of, well, if I want my students to get the grade that I actually think they will get, I may need to be particularly sort of optimistic stroke positive in the way that I position their prediction. And it was very difficult to work out which schools had adopted which approach for which students. So what then happened was the centre assessed grades initially were submitted to Ofqual. Ofqual then applied their algorithm to the centre assessed grades, and in August everybody got their moderated grades. Now, when the moderated grades came out, there was uproar because 36% of grades, of moderated grades, were 1 grade lower than the centre assessed grades that the teachers had put in. 3% were 2 grades lower, and you can imagine the impact on university places, on young people's aspirations. So there was an uproar, and there was a period in August of a couple of weeks where the government said, no, we think this is fit for purpose, we think this is absolutely fine. The government's moderated grades resulted in about 25.2% of grades being top grades, so the highest grades. And then the government did a U-turn effectively and said that actually students could have their centre assessed grades unless their moderated grades were higher, in which case they could keep their moderated grades. Now, what that actually meant was that we went from a situation where 25.2% of grades were top grades to 37.7% of grades being top grades. So that shows, well, that doesn't show necessarily anything, but it obviously adds grist to the mill of centre assessed grades might be inflated. And then you've just had an awful lot of difficulties because many children got their centre assessed grade or their higher grade too late to be able to take up their university place this year. Some children and young people felt very aggrieved because they then found out that their centre assessed grades were a lot lower than they had expected, bearing in mind what they had been predicted for A level. There were tremendous difficulties with how you dealt with reasonable adjustments, with, I think, some schools saying that if you hadn't put in for reasonable adjustments for your A level exams, which would have been back in sort of November or December the previous year, then you wouldn't be treated as somebody who required a reasonable adjustment when the centre assessed grade. So, I mean, in short, it was a very difficult situation that unfortunately resulted in a very difficult outcome. And I suppose the only saving grace of it was that some young people were able to just resit the exam because resits were available in November and December, although obviously lockdown number 2 has resulted in some young people who were waiting until this year to retake not being able to retake. So it was a very difficult time. I think you have to have a certain amount of sympathy with the government and with schools for the situation that they were in, but unfortunately it was, let's just say, it was not an unmixedly positive outcome for anybody. So that was 2020.
Very much, Charlotte. And yes, a really comprehensive summary there. I really like that you included some sources from the street. I mean, the mean streets of education are known to be rife.
I'm there with my ear to the ground.
Well, that's why, you know, on location, you know, on the mean streets of education, getting the latest information for the show. So really, really appreciate that. But I think the statistics you brought forward really meaningful as well. You know, 25.2% following the moderation process, up to over 37% when we went back to teacher assessed grades. So a clear sign that there was a quite significant disparity between those two different grades. Now, we've talked about 2020 and the fiasco that surrounded those grades. So Lachlan, is there more positive news for 2021? What is the outlook?
Well, what I can confidently predict, and no lawyer predicts anything to 100% degree of success, is that there is likely to be another fiasco. The outlook is not certain at all. The forecast is certainly changeable. As at the beginning of December 2020, the government were rooted to exams taking place this summer. Indeed, the current guidance that exists on the government website speaks to that conclusion. Politically, but without giving legal guidance on the issue, the government has done perhaps one of those U-turns that the government is eternally criticised of doing, and has said that there will not be exams in the summer, certainly in England. And Wales, of course, has said similarly. What this means is you would expect to be able to turn to the DfE website with some nice, clear guidance on how schools are going to provide their students with grades at the end of the summer. And you might legitimately expect that halfway in the spring term, before the summer term, at which certainly the A levels will be over about halfway into the summer term. So we've practically got just one school academic term left before these exams are sat. Do we have certainty? No, we don't. The government has consulted, and it's consulted specifically on 3 issues that it really wants to deal with. First, the government, as I've suggested, has announced that the students' grade in the summer of 2021 will be based on their teachers' assessments. So similarly to finally the conclusion reached in 2020. But of course, as Charlotte has outlined, that met with all sorts of moderation issues, not least because of the algorithm fiasco. Mm-hmm. So it's not an algorithm that they turn to now, but they have consulted to seek views on how teachers can be supported to make their assessments fairly and consistently. And that, of course, is going to be the central focus on how you won't get teacher assessed or centre assessed grades being so disparate across the country. If there is very clear guidance given to teachers, given to centres on how to make their assessments and not to take into account aspirations, wishes, desires, last minute crammers, all sorts of those issues that can give rise to disparity in treatment. If there is certain guidance on that, we are to expect it. Hopefully, the consultation is now closed, but hopefully the consultation has informed on that, and we are to expect guidance on how teachers can make their assessments fairly and consistently. Interestingly, the second proposal that the government was concerned to make sure was on offer is the ability of an appeal, the availability rather of an appeal. So students who don't believe their grades reflect the evidence of the standards at which they are performing should be entitled to some form of an appeal. So, and again, the government has consulted on that, so we are to expect, hopefully, some certain guidance on that and how those appeals are to be brought. And then finally, the government was seeking consultation on pupils who aren't studying within a school or college because, for example, they're home educated. It's desired that such students should be issued with a grade 2, and the government was seeking options on how that could be fairly done. Not that the government, I'm sure, was suspicious that any parent of a child home educating would not believe their child to be capable of achieving the highest grades possible. But of course, that is something to be addressed in the consultation, and hopefully we shall see guidance on that too. But we haven't got it yet. So we've got no exams, we've got centre assessed or teacher assessed grades, but with no certainty as to how fairness is going to be achieved in that scenario. That's where we are.
Can I just come in with a couple of positives that I've picked up from what Lachlan has said, which is firstly, the absence of an algorithm is probably good news if they stick to that, because one of the difficulties with the algorithm last time was that because it kind of relied on a sort of pattern of grades across a cohort, if you were in an independent school with a small class size, you were more likely to get a high grade than you were if you were in a state school with a bigger class size. And that was one of the most awful results of the algorithm, that it actively prejudiced people who were in public education as opposed to private education. Yeah, it's quite possible that that is potentially the only positive, I suppose. The other one being, it's nice that they're consulting on children who are not in in a school or a college, where they can be assessed across a whole year, because that was also a very big issue for students who were retaking at sixth form colleges and maybe not regularly going in last year, or who were being or who were doing independent study. So there are some positives there, but it's not encouraging, is it, Lackers, that we've ended up in a situation where 2021 so far is almost horribly mirroring the progression of thought and idea in 2020.
Absolutely not. And as I say, so close we are to actually the exams or the exam grades that are to be expected. Yeah.
Well, thank you both for your contributions. And Charlotte, you mentioned about the difficulties those who may require reasonable adjustments to their examinations. So in terms of 2021 and looking forward to those exams, what is your advice to young people and parents of young people who require those adjustments? How should they go about notifying the school of these?
So schools and colleges should have, well, I think the first thing is, the most important point to make is, do raise it now if you think that you have a disability that may require reasonable adjustments around examinations or assessments. So if you think you would need a reasonable adjustment for an exam, don't be tempted not to raise it because you're going to be assessed across the year rather than in an examination. It's really, really important to get that information to your school or your college as soon as possible. Your school or college should have a SENCO, a special educational needs coordinator. that's probably where you would start, I would have thought, Chris, although actually you've probably got more experience of alerting schools to the fact that students may have SEN than I do. But that's where I would go. And the key thing is get it in early and get your evidence together in support early as well, because it's really important when your school assesses your centre assessed grade that they treat you as somebody who would require reasonable adjustments.
Absolutely right. And yes, you know, if you are a person, particularly if you have an EHC plan or a statement of special educational needs, you know, you will usually have had contact with the SENCO, or in Wales, the ALNCO. Do feel free to contact them. If you haven't had such experience before, and if you've generally dealt with examination adjustments through the class teacher or through the head of year, then they would be the person to contact. But again, as with our previous topic, it's dialogue, dialogue, dialogue. Do get in touch early and often to try and emphasise the problems that you're having and the support that will be provided for your child or young person's needs. Now, finally, we come on to our final section, which is our case comment. And today we're going to be talking about the case of AB and University XYZ. This was decided right at the end of last year, so pretty recent by law standards. And we will go on to discuss the consequences that has for students who are facing disciplinary proceedings at their university. And now we come to our case comment, and as explained earlier, we are discussing the case of AB and University XYZ. This was decided in November 2020 and relates to student disciplinary proceedings at university. Now, if you're curious about the names in the case, please understand that they were anonymised, and that is why you are dealing with the letters A, B and XYZ, when of course, in reality, the identity of both the university and the student have been kept confidential for understandable reasons that will come on to the sensitive nature of this case. But before we come on to discussing this case in particular, Lachlan, I know firsthand that you deal with a lot of university cases and are somewhat of an expert in that field. So perhaps you could tell us a bit more about the standard university disciplinary process, what it covers, and how is it normally handled at a university level?
Sure. Okay, and I will focus particularly on the rights or otherwise of the student who is alleged to have fallen foul of the disciplinary process to have legal representation or to have representation of any sort. And normally, and most disciplinary processes within universities do not extend an entitlement or a right to the student against whom an allegation is brought to legal representation. In fact, very few extend to any form of representation. What they tend to offer is the ability for the student to be accompanied, to be supported. And how that tends to work in practice is that the student may have somebody from the university, either another student or indeed some member of the teaching staff from a faculty accompanying, but they're not able or allowed, and the process that the universities tend to operate doesn't allow that person to speak on the student's behalf, but it does allow that person to take time out to sound off with that supporter to check what that supporter thinks the student should be focusing their defense on, and to come back to the panel and report back to the panel and give evidence that way. But that is, what is that? That's not a million miles from the companion that someone is allowed in a workplace disciplinary. It is not a representative, and it's not somebody who is making submissions on the student's behalf. And of course, what this case touches on is not just the entitlement or otherwise for the purposes of achieving a fair process to representation, but also entitlement to legal representation. And in those universities, there are some universities out there who do allow the support worker to be a legal representative. And that tends to happen more in the types of vocational studies that are required to go on and get a vocational job. So where you have fitness to practice proceedings, for example, within the university context, and they will have some damning sometimes implications on that student's ability to practice in the profession that they are training to practice in. In those circumstances, universities have tended to offer the ability for the student to be accompanied by a legal representative because of the ramifications or the implications that being found guilty of the charges might have flowing from the university, going out from the study days, so to speak. But not all universities do that. And even in those circumstances, some universities say you're entitled to a legal representative to support you, but that legal representative must act in a supportive capacity, not in a representative capacity. So it's not clear. There's no consistency across the board, but those are the sorts of criteria that are taken into account in disciplinary processes normally.
Thank you very much, Lachlan. And yes, you're quite right. The approach is definitely not uniform. It can change from university to university, from subject to subject. And yes, you're quite right. For those who are pursuing what we would say maybe professional degrees, i.e. degrees that are regulated or at least allow for entry into a professional body, be that lawyers such as ourselves, doctors, dentists, social workers, etc., there can be very serious ramifications, not just to that student's attendance on the course if they are found guilty of misconduct, but potentially their ability to enter into their chosen profession at all. So there can be very, very serious ramifications to this. So Charlotte, that brings us on, I suppose, to the case at hand. So can you please give us an explanation of this case and, most importantly, what the court said about legal representation at the university level?
Yes, so this was a case where the student was accused of a very serious sexual assault. So it wasn't a sort of trivial allegation. It wasn't anything to do with any breakdown in relations with another student or anything like that. Not that that would necessarily be trivial, but this was something that, could have attracted a prosecution, could have attracted a criminal sanction. It really was of the utmost seriousness, and it affected the student's future in a variety of different ways. And the university's position was that the student was not entitled to legal representation for the reasons that Lachlan's already described, the sort of standard university position. Now, this was a case that was heard in the High Court, and the judge who heard the case went off and looked at some previous cases that had been decided in other contexts about when you might be entitled to legal representation when you're dealing with allegations or a case against you that isn't somewhere like the Crown Court or the County Court or the High Court. And he looked particularly at a case called Tarrant, which is about when prisoners are entitled to representation in proceedings relating to their status as a prisoner. So on the face of it, it's quite a different sort of scenario to university. Most people do not feel imprisoned at university, but there were some principles in that case, which I'm going to call the Tarrant principles, which the judge pulled out and looked at to decide whether he thought this student should have been entitled to representation in his disciplinary proceedings. So the first thing that the judge said you should look at on the basis of the Tarrant case is the seriousness of the charges. So is this something that is very, very serious, which in AB it was, or is it something that isn't that serious that maybe would earn you, a kind of slap on the wrist or a minor reprimand? The second question was whether points of law were likely to be raised. So was this something that any layperson could deal with without any legal training, or was it something that really required quite a sophisticated knowledge of how the law works and the ability and experience of arguing points like that in formal proceedings? Because obviously if the answer was yes, those points were coming up, that might point more towards a lawyer being involved. The third question I think is a really important one, which is what is the capacity of the student to understand the case against them? So obviously somebody who is in receipt of education at a higher education level is probably going to have capacity to carry out a degree and go to work. But within that, there's obviously the question of what of whether there are any disabilities that are operational or some other reason why a student might really struggle in that particular situation. So there are lots of students who will be capable of doing very high level, very difficult degrees, medical degrees, law degrees, other sorts of very complicated technical degrees. But they may have a disability that may really impact them in their ability to participate in a disciplinary hearing. And obviously that, combined with the seriousness of charges, would be a reason to instruct to allow them to have a lawyer. The next question would be whether there were any procedural difficulties. It's quite a wide category, but it's obviously something that would need to be looked at. And whether there was a need to avoid delay. So would having a lawyer involved in a very serious and urgent case mean that the case wouldn't be take an unnecessarily long time? And finally, the need for the student to be on an equal footing with the university, for there to be fairness between them. Sometimes that will point to having a lawyer involved and sometimes not. But you can certainly imagine that if the university had a lawyer involved, it would be very difficult to see how they could justify saying that the student should be represented as well. Yeah, so looking at all of those 6 principles, deterrent criteria, the judge came to the conclusion that whilst you wouldn't necessarily say that students were entitled to legal representation in all disciplinary proceedings, every case had to be looked at on its facts. And in this case, the case of AB should have been entitled to legal representation.
Thank you, Charlotte, for that extremely helpful summary. So, Lachlan, we'll come back to you again, as someone who deals with these types of cases, as do I. So this does seem to be, I suppose, a shot across the bow somewhat of universities who have this blanket ban policy on legal representation. So is this a success for student rights?
It is certainly a shot across the bows for any blanket ban, because no university should be operating a blanket ban. And what this says is actually, in the circumstances, consideration needs to be given to the individual circumstances to determine whether fairness requires representation. And ultimately, that is the test. The test is fairness. But there was recognition that these proceedings shouldn't become too adversarial, and that permitting legal representation should not be the routine. And that was the paragraph 88 actually of the judgment repeated, and it was repeated remarks of Lord Hope in an earlier case about the dangers of allowing legal representation. So fairness does not always mean that legal representation should be allowed. And when considering fairness, it's important to remember that that 8th point in the Tarrant guidelines means also fairness to the complainant as well. So in balancing fairness, that is what is determinative as to whether legal representation is required along the Tarrant guidelines. So any blanket policies banning legal representation, well, those should be things of the past, the dark ages, and universities should have moved on from that. And if they haven't, then certainly this case will hopefully encourage them to do so.
Excellent, thank you very much. So as we can see, the blanket ban to legal representation has certainly received a significant blow and may very well have come to an end. However, we need to caveat that by saying that, it won't apply to all disciplinary proceedings and will be dealt with on a case-by-case basis. So again, much like we have with all circumstances, think of your own personal circumstances, think about those principles that the court discuss, and try to apply your own circumstances or those of your child, if they are facing disciplinary proceedings, to those circumstances. And of course, if in doubt, always take advice. Even if legal representation isn't required, as Lachlan has discussed, you may be entitled to receive legal advice on the structure of your appeal or the structure of your defence, and that can be extremely helpful. And even if they aren't allowed to speak on your behalf, you may be entitled to have a legal attendee alongside you at the hearing who can perhaps assist you in the presentation of your own case. So with all those topics discussed, it now brings us to the end of our Education Law magazine. Now, Charlotte, I think it would be remiss of me to overlook the fact that you are joining us on location, it appears, from your car. So you're presently muted, but I was hoping you might explain to us your dedication to the programme is such that you've joined us remotely. So can you give us a bit of an explanation in
That's
that
right.
regard.
I can. I have some people who've seen some of my other seminars will have seen my faithful friend, my black and white greyhound Jasper in the background. Jasper, unfortunately, is not very well at the moment and has had to go to dog hospital, where I am hoping that he will soon be restored to his normal state of bullish good health. But such is my dedication to the Education magazine, Chris, that I said to you, I will join you by car from a Tesco car park, and that is where I am now.
Excellent. Well, thank you, Charlotte. We really do admire your dedication to the cause. And just to reassure anyone at home, Tesco does not sponsor the magazine. And Lachlan, thank you very much for your first attendance on the show. Very grateful to have you, particularly at short notice. Did you enjoy yourself?
I certainly did. And your observation that certain supermarket might not sponsor the magazine, but I know for a fact that it has a shelf dedicated to doggy treats such as gravy bones and dentist sticks. And I have no doubt that Jasper, the canine, is deserving of them, and I hope he'll get lots of them given Charlotte's location. But Chris, it's been absolutely fantastic, and a pleasure to join you and make what small contribution I can in the circumstances.
Welcome contribution indeed. Thank you very much. And yes, we here at Sinclair's Law always, Jasper, a speedy recovery. So that brings us to the end of our magazine programme. In summary, we know that children are returning to school, and some of those children have already returned from the 22nd of February here in Wales, and others will return from the 8th of March onward. As ever, if you're anxious about your child returning or if adjustments are needed, again, dialogue. Speak to the school, speak to the local authority, try to work out arrangements for your child to attend school, either in person or remotely. Or alternatively, if there is no solution to hand, perhaps you should consider elective home education, but do make sure you've got proper plans in place to carry out that work. On to A-levels. Well, there is still some uncertainty about the arrangements to come for 2021. And yes, we do appear to be repeating ourselves a little bit with the arrangements from 2020. However, there is also room for positivity, as we heard teacher assessed grades, which appear to be the norm for 2021 as well, were pretty good. 37% of pupils did receive the top grades, and that is naturally a wonderful outcome for those pupils. But of course, we also need to recognise that that does come with complications, particularly for those who may have had examination adjustments. So again, dialogue. Make sure you speak with your school if you have concerns about your child disability, or of course if you're a young person yourself who feels like they need to talk to their school about examination arrangements and how those are going to be taken into account. Do have that discussion. And finally, the case of AB appears to have had, I think, a welcome strike to these blanket bans on legal representation, particularly for students who are facing complex or serious allegations that may impede their ability to carry on with the course or even to practice in their chosen profession. Although there is now no longer a rule that you must have legal representation or a general entitlement to it, at the very least, the university should consider your case on an individualised basis and come to a decision. And as ever with such decisions, they may very well be susceptible to challenge. So if in doubt, do take advice. For all of you watching today, I would like to thank you very much for joining us, and I'm sure that Mr. Charles will welcome you back next time in his usual role as host. But until then, goodbye.